So this is how it goes. It's sort of like school. We turn up in time, put our bags away, and await to hear what goodies are in store for us for the next few hours. Proceedings begin with a question, usually addressed to the departments, either DFI or DOE, and are revealed with drip-like progress over the course of the day. We all sit waiting for the next question to be released from the lips of the Reverend Mother of the Universe. Apologies, of course I mean the Commissioner. There's a frantic scribbling of notes as we endeavour to capture at least the essence of the question as each pearl of wisdom falls. In my case, I'm lucky if I can manage to write down half of what has been pronounced, not least understand it thereafterwards. In this world, a truly different language is spoken. They're quite fond of the abbreviations, acronyms and truncated words. I think it's English, but I couldn't be certain, joking aside. The day started by returning to two overnight issues. Mr. Fagan, barrister for FODC, agreed there had been a failure to comply with planning conditions, but stated that enforcement does not require the removal of the infill. This relates to a case inherited by the Council, originally investigated by the Department DOE in 2014, which concluded there had been no breach of planning control. However, the original permission was a temporary 3-year consent with no environmental impact assessment required. The application clearly stated that the land should be restored to its original condition, which did not include unauthorised infill. This raises the question of how DOE could determine the development was acceptable without proper planning assessment. In essence, Dalradian's use of landfill appears unlawful, potentially circumventing EIA regulations, which say unauthorised development should not be retrospectively legitimised or used to gain an unfair advantage by bypassing environmental law. Just to clarify, EIAs focus on the environmental effects of specific projects, assessing their impacts before planning permission is granted. The other overnight, somewhat contrary topic was, of course, the cyanide. When the DFI came back with the proposed conditions for cyanide, you could have heard a pin drop as we listened carefully. No cyanide or cyanide-based compounds shall be brought onto, stored, handled, used, disposed of anywhere within the application site at any time, whether directly or indirectly, in connection with the construction, operation, processing, treatment, mitigation or decommissioning of the development hereby permitted. As I said yesterday, we all thought that the cyanide had been removed permanently from the files, but it seems not. It was decided that this discussion would be moved to the designated day for mine waste. I think there was a collective sigh of secret relief, as it is one contentious topic. After this, the questions came thick and fast, ranging from the discussions about the precautionary approach to the lack of a HRA. Yes, we're back to the abbreviations. HRA, also known as Habitats Regulations Assessment. I think if I had a name like that, I would be shortening it also. Turns out it doesn't matter what it's called because it doesn't exist. Yes, you've heard that correctly. There is a shadow one produced by the company, but it is somewhat treated for the main mine and water applications. Why is this important? Because the HRA is crucial to ensure a mining project does not harm protected habitats or species, especially in designated sites. It assesses potential impacts on conservation areas and ensures compliance with strict environmental law. Without a HRA, a project cannot legally proceed if there's a risk of significant ecological damage. One thing one might say about the process is that the conversation is broad. In one instance, we grappled with turbary rights and the Crown estate in the same conversation. Who knew that these two topics could be bedfellows, albeit reluctantly? Our next topic took us to the hen house. Well, not quite. The question was around issues of conflict of interest raised by third parties. That's us again. There were many examples quoted in the room and offered up. Some were accepted and others were shot down in flames. The most significant one seemed to be around a company called Golders, who designed the original development for the mine. Nothing wrong with that. But now it appears that they are employed by DFI to oversee and review their own work. Hence my mention of chickens, in that you wouldn't ask a fox to guard the henhouse. And on that intriguing thought, I'll bid you adieu. I'll be back next week.